other than in cases which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard in a matter, we ask that you fill out a speaker card and give it to this nice lady in the back, Ms. Fulford, who has raised her hand. All right, next item is approval of our minutes from January 25, 2019. Is there a motion?
Motion.
Thank you. Is there a second?
Second.
We have a motion to approve. It's been seconded by Commissioner Brady. Any discussion on the motion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. Motion carries. Minutes are approved. All right, our first item for today under agenda item 4, consideration of final action on a joint stipulation. We'll call the case. It is In re Elliott Cohen, case number 2016-192. Advocate Miller, please make an appearance.
Elizabeth Miller, advocate for the Commission on Ethics.
All right, I believe we do not have a complainant present today, but we do have a representative of the respondent.
Mark Heron on behalf of Elliott Cohen.
Welcome, Mr. Heron. Glad to have you. All right, Commissioners, we have before us a proposed stipulation between the Commission advocate and the respondent. The Commission may vote to approve or to reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at DOA, the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations, but we have not received any comment from the complainant in this matter. All right, Ms. Miller, please present the stipulation.
Thank you. Good morning, Commissioners. The parties have entered into a joint stipulation. At all times pertinent, the respondent served as the Director of Communications for the City of West Palm Beach. He also was the owner of a public relations and marketing firm. In the stipulation, the respondent admits that he misused his public position by soliciting business for his private business. He admits that he had a contractual relationship with a business entity that was doing business with his agency. And lastly, he admits that he used information he learned through his public position to benefit himself in his private business, or at least attempt to benefit himself in his private business. We've agreed to $1,500 per allegation for a total of $4,500. I agreed to forego a public censure and reprimand because the respondent voluntarily admitted without qualification that he violated the Code of Ethics. We ask that you accept and adopt the joint stipulation.
Thank you, Ms. Miller. Any questions for Ms. Miller? All right, seeing none. Mr. Heron, anything you'd like to present?
I have nothing further to add to what Ms. Miller has.
Thank you very much. I presume we have no questions for the respondent. Yes, thank you. Is there a motion to adopt the stipulation?
So moved.
I have a motion from Commissioner Brady, seconded by Commissioner Shields, McManus. Thank you, Commissioner. Any discussion on our vote, on the motion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. The motion carries. Thank you to the parties. All right, our next matter, item B, In re Richard Romanoff Jr., case number 2017-053. Ms. Miller, this is also a consideration of final action stipulation. Same rules apply. Appearances on behalf of our respondent.
Mark Heron on behalf of Richard Romanoff.
Thank you, Mr. Heron. Is our complainant present? I don't believe so. All right. Thank you. Please proceed, Ms. Miller.
Thank you. Elizabeth Miller, advocate for the commission. Again, this is a joint stipulation. The respondent serves as the chairman of the Board of Supervisors for the University Place Community Development District. In the stipulation, the respondent admits that he and his wife, through their private business, were doing business for payment with the respondent's public agency. Secondly, the respondent admits that he and his wife, again through their private business, contracted to provide services to his public agency. I've agreed to $1,000 per allegation for a total of $2,000. Again, did not, or agreed to forego a public censure and reprimand because the respondent unequivocally admitted to the allegations and violation of the code of ethics. Thank you.
Thank you, Ms. Miller. Any questions for Ms. Miller? Seeing none, any further comments from the respondent?
Again, Mark Heron on behalf of Rick Romanoff. We'd urge you to adopt this joint stipulation. You may recall from the report of investigation, this is one of those cases where Mr. Romanoff actually thought and had sought advice from counsel and thought he was actually following the law. Once it was explained to him that he wasn't, he authorized us to enter into this joint stip. Thank you.
Thank you, Mr. Herron. Any questions for Mr. Herron? Seeing none, is there a motion?
Motion.
We have a motion from Commissioner Berger, a second from Commissioner Lesnoff. Any discussion on the motion? All in favor, please say aye.
Aye.
Any opposed, nay. Commission approves the stipulation. Concludes the case. Thank you. All right, our next matter is In re Ricardo Rick Fernandez, complaint number 2017-106. I believe that we have the complainant here. Mr. Jackson, will you enter an appearance, please? Just stand and say, here. Thank you, sir. On behalf of the respondent,
Mitchell, on behalf of the respondent, Rick Fernandez.
thank you, Mr. Mitchell. Welcome. Ms. Miller, please enter an appearance and you may proceed.
Elizabeth Miller, advocate for the Commission on Ethics. The respondent was the city manager for Tallahassee, and as such, he was also a reporting individual. Commissioners, it is unlawful for a reporting individual to not disclose a gift if he believes that it's in excess of $100. There are limited exceptions that are not applicable in this case. The respondent admits that he accepted a gift in the form of a discount on a bill for his daughter's wedding reception, and he didn't disclose it on a CE Form 9. Secondly, it is unlawful for a reporting individual to solicit a gift from a vendor doing business with his agency or from a lobbyist who lobbies his agency. The respondent admits that he solicited FSU football tickets from a lobbyist for seating in the lobbyist skybox for himself and for his family. Each ticket costs approximately $128. The respondent admits that he solicited these tickets, and the civil penalty we're asking for this offense, or this violation, is $2,500. For the previous violation, that is failure to report, we're asking for $1,000. The next violation is accepting a gift from a lobbyist. It is also unlawful for a reporting an individual to knowingly accept a gift from a lobbyist who, again, lobbies the reporting individual's agency, if he knows or reasonably should know that the value of the gift is in excess of $100. The respondent admits that he accepted gifts in the form of FSU skybox tickets to 4 football games. For each violation, we're asking a civil penalty of $625 for a total for this violation of $2,500. So the total penalty we agreed to is $6,000, along with a public censure and reprimand. I would like to point out that the respondent resigned from his public position effective January 3rd, As a consequence of these allegations, we request the remaining allegations be dismissed because they are either incongruent with the allegations respondent admitted to or because it was part of the negotiation. We ask that you accept and adopt the joint stipulation. Thank you very much.
Thank you, Ms. Miller. Any questions for Ms. Miller? Seeing none, Mr. Mitchell, on behalf of the respondent.
Thank you, Chairman. I have nothing to add. I'll be happy to answer any questions if you have any.
Any questions for Mr. Mitchell? Seeing none, we will proceed. Reminder to the commissioners, the complainants have the right to comment in writing on proposed stipulations in this matter. We have not received any comment from the complainant with respect to the stipulation. Therefore, if there are no further questions, it's appropriate to proceed to motion. Yes.
I just wanted to ask Mr. Mitchell one quick question.
Okay, we do have.
And it's really the same question for both parties. My understanding in reading this is both sides looked at all of the facts, circumstances, and accounts, and there was an admission they came to a best interest agreement. He's no longer serving in office, so you all basically had a best interest agreement based on facts, circumstances, where it could go, trial, appeal, etc.
Any further questions? Seeing none, Chair will entertain a motion.
Move to accept the settlement of stipulation as presented.
Thank you, Commissioner.
Second.
I have a second from Commissioner Meggs. Any discussion on the motion? Commissioner Brady.
Yes, I made the motion because I do remember in the hearing, it was at least my sense that the discussion regarding the wedding was rather convoluted and somewhat difficult to follow, and find that this is a much more judicious presentation of what the actual allegations and offenses were.
Anything further? Commissioner Leslie.
Yeah, and I acknowledge that I was not here for the original presentation, but in my reading of the record, the issue about the wedding, it appears that he gained more benefit from that gift than his penalties are today, and he is not admitting to, although he's admitting to not recording that gift or disclosing that gift, he's not admitting to receiving it, and therefore I won't be supporting the motion today.
Okay. Mr. Mitchell, is there something you wish to offer, or are you just ready to field any more questions?
The only way I could address that is that he is actually admitting to receipt of a gift and not reporting that gift in that particular allegation.
All right. Thank you, Mr. Mitchell. Any further discussion on our motion? All in favor, please say aye.
Aye.
Any opposed, nay.
Nay.
The motion carries. Stipulation is approved. All right, our next case is In re Alfredo Santa Maria. The complaint number is 2018-140. Ms. Hadley is our advocate on the matter. We have no, the complainant isn't present, correct? All right, so we have no other appearances either by the respondent or the complainant. Ms. Hadley, please enter an appearance and you may proceed.
Melody Hadley, Commission Advocate. Respondent was a candidate for the Miami-Dade County Commission. It is alleged respondent filed an at the time I bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file his 2017 CE Form 6 in violation of Article 2, Section 8, Florida Constitution, and Section 112.3144. He has since filed an amended form. I asked the Commission to accept the respondent's stipulation that he violated the aforementioned law and recommend a total civil penalty of $750.
Thank you, Ms. Hadley. Ms. Hadley made clear, I should have mentioned it in advance. However, contrary to the other three cases, this is a pre-probable cause stipulation on the matter. so it's not previously been before the commission. Any questions for Ms. Hadley? Seeing none, we have no appearance by the respondent. Is there a motion? Okay, I'll take that as a motion to approve the pre-probable cause stipulation, and it has been seconded by Commissioner McManus, I believe that was. Thank you. So we have a motion, and it's been seconded to approve. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. Motion carries. This concludes that matter. All right, we will now move to item 5, consideration of advocate's motion to dismiss complaint. This is in re Joseph Kilsheimer, case number 2017-047. Mr. Herron, I believe, still with us. Yes, he's here on behalf of the respondent. Anyone here for the complainant? No, thank you. All right, Ms. Miller, please enter an appearance.
Mr. Chair,
Yes,
just like to disclose that I know Joe Kilsheimer prior to him becoming mayor. We had professional relationships. It will not influence my decision on this case.
thank you. Any other disclosures? Thank you. So the advocate has moved to dismiss the complaint based on information obtained during discovery. Ms. Miller, please proceed.
Thank you. Elizabeth Miller, advocate for the commission. Commissioners, I recommended probable cause in this case, and you did find probable cause. The case was sent to the Division of Administrative Hearings for a formal final hearing. During the course of preparation for the hearing, we took depositions. We did further investigation, and it was determined that a violation did not occur. I am now requesting that the complaint be dismissed based on further facts. Thank you.
Thank you, Ms. Miller. Any questions for Ms. Miller? Seeing none, Mr. Herron, anything you'd like to add?
Other than to urge the commission to adopt the motion to dismiss the complaint as recommended by the applicant.
Thank you, Mr. Herron. I presume no questions for Mr. Herron. We'll proceed for a motion.
Motion to approve the recommendation to dismiss.
Thank you, Commissioner Berger. Is there a second? Second from Commissioner Lesnoff. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. Motion carries. Case is dismissed. Next set of items, or our next item on our agenda, Commissioners, is consideration of advisory opinions. We have just one today, so won't be exercised quite as much as normal. This is file number 2733, and it is relating to post-employment restrictions from a former Assistant Secretary of DCF, employed by a DCF contractor, and I believe it's Deanna Roming is presenting our opinion today.
Yes, sir.
Oh, our requester is present.
Yes, she is.
Welcome.
May I proceed, Chair?
Please.
All right, thank you, Chair. Commissioners, this opinion concerns Ms. Rebecca Capusta, an employee of the Department of Children and Families, DCF, who is seeking employment with a company that has DCF contracts. Ms. Capusta would like to know whether a prohibited conflict of interest would be created if, after leaving public employment with DCF, she were to hold employment with a company in connection with contracts for which she was not personally and substantially involved in procurement, but which are among several legislatively mandated community-based care, or CBC, contracts with which her department's subordinates were somewhat involved in oversight. During her tenure with DCF, Ms. Capusta has served in several roles, including as General Counsel, Interim Secretary, and Assistant Secretary of Operations, her current position. As Assistant Secretary of Operations, amongst other things, Ms. Kapusta manages 6 regional managing directors, or RMDs, who not only sign the contracts held with the legislatively mandated CBC lead agencies, but also work on the specific performance of these same contracts. 2 provisions of the Code of Ethics for public officers and employees are relevant in this instance. The first is Section 112.3185, subsection 3, Florida statutes. However, because Ms. Kapusta did not have any involvement with the procurement, development, award, or approval of the existing contracts between DCF and her prospective employer, her prospective employment with the contractor would not be restricted by this statute. The Commission in CEO 1220 found that a similarly situated DCF Assistant Secretary would not be subject to this section where he had not participated in the procurement of a DCF contract with his prospective employer, which, as in this instance, was also a CBC lead agency. However, if applied in isolation, Ms. Kapusta would be restricted by Section 112.3185, subsection 4, Florida statutes, which sets out a 2-year restriction on former public employees holding employment or a contractual relationship with any business entity in connection with any contract for contractual services, which was within the employee's responsibility. Nevertheless, the Commission in the CEO 1220 opinion found that certain factors led themselves to the application of 112.316 Florida statutes, which would negate this restriction. The particular circumstances of this matter, as outlined in the draft, happen to include the same factors that the previous Commission considered and which resulted in a favorable finding of no conflict of interest. Additionally, it is important to note that although the facts and circumstances of this opinion are very similar to that of the requester in CEO 1220, Ms. Kapusta has never served as a managing director of any DCF region, whereas the requester in CEO 1220 did serve as a central regional managing director for 10 weeks prior to becoming Assistant Secretary of Operations, a position that he held for about 11 months at the time the Commission considered that opinion in August of 2012. As of today, Ms. Kapusta has also served in her role as Assistant Secretary of Operations for a combined time of about 11 months. Therefore, I think it would be similarly appropriate to apply Section 112.316 to negate any restrictions that would arise in Ms. Kapusta's situation via the literal language of Section 112.3185, subsection 4. I now present this draft for your review, and Ms. Kapusta and I are happy to answer any of your questions.
Thank you very much. Any questions for our counsel from the commission? Yes, Commissioner Brady.
So I understand the opinion, even though the requester held fairly significant, powerful, authoritative positions in DCF, because she wasn't the regional district manager, we don't believe she was engaged in any discussions regarding the awarding or monitoring of these contracts?
That is, through the chair, that is correct, Commissioner Brady, and Ms. Kapusta could elaborate on that more. She was not involved in those actions.
Any other questions for counsel? Seeing none. Ms. Kapusta, you are welcome to address the commission if you wish. And would welcome. No, ma'am, please come all the way up to the microphone.
Good morning. Thank you for having me this morning. To answer your question, when those contracts began with Eckerd, which is the prospective employer, I was actually in the Northwest region. So DCF is split into 6 regional areas of the state, and the Northwest region serves the Panhandle Circuits 1, 14, and 2. I was here as an assistant regional legal counsel. I had no interaction or involvement in the Suncoast region, which is where ECHRD exists right now. When those contracts were originally entered into, procured competitively, I didn't even know ECHRD existed, to be honest with you. It wasn't until I went to the Suncoast region when I became involved and aware of ECHRD as a CBC lead agency in that region, and I served as interim secretary for about 4 to 5 months. But at that time, ECHRD was already in existence.
Awarded the agreement. Was already awarded the agreement.
Correct. They had already been awarded the agreement. I think by former secretary, probably Sheldon at that point. I don't know. It went back some time.
Commissioner Lasnoff also has a question.
So, but you would, as an acting secretary or interim secretary, you would have had involvement or potential interaction in the management or some dealings with this entity?
Frankly, during the time of my tenure as secretary, which was, again, about 4 to 5 months, I was significantly distracted with issues involving Hurricane Michael. It was recent that I was interim secretary.
And you were,
we were running operations for our DSNAP events, so disaster supplemental nutrition events for those folks who were impacted by the disaster of Hurricane Michael. So I really didn't have much involvement at all. We had another procurement going on for our lead agency down in Miami, which is our southern region. So those were the main focuses of what I was dealing with as secretary. But I really did not have any direct involvement with what was going on with ECHRD. It was really the regional managing director who was overseeing those contracts in the Suncoast region.
Yes.
and you're Assistant Secretary of Operations as well?
I am.
And how long have you been in that position?
So I was general counsel. I've been with the department for about 18 years. So I was general counsel from 2014, May of 2014, until December 22nd of 2017. In 2017, December 22nd, 2017, I transitioned into my role as Assistant Secretary of Operations. And then in September of 2018, so about 9 months later, I transitioned into my role as interim secretary until about January 14th, when Secretary Popple came on board. And I transitioned back into my role as Assistant Secretary of Operations.
Thank you.
Commissioner McManus.
Good morning. When were you first approached by your future employer for this private position?
It was after Secretary Popple was announced as secretary. The question came to me as if I had made any transition plans. And I said, I need to figure some things out before we have those conversations.
Okay, so are you still employed by the department? And you don't have any present contract with this private employer?
The department has a contract with the private.
Well, I mean, as far as you're being employed in the private capacity. Okay. So are you making any judgments, overseeing any contracts with this potential employer of yours?
No, sir. In fact, the Department of Children and Families knows that I'm here. I've made them aware of the fact that I have this potential job opportunity, and they understand that I will be leaving to go work with ECHRD so long as the commission says that I am cleared to do so.
Thank you.
Any further questions? Counsel? Sure, Commissioner Carl.
First, on behalf of the person requesting, thank you for your service. DCF is one of the my experience, more difficult and sometimes thankless, but very important, so thank you for that. To counsel, the gist of the request is basically that if somebody is not involved in the decision-making for the for a contract, then they may be open to possible employment after the fact. Is that what the basic impetus is here?
Through the chair, Commissioner, that's a simplistic way of putting it, but
That's how I
essentially.
live, so it's okay.
It's okay. But essentially, yes, what we're asking the commission to do is what was previously done in a case that is pretty much on point, other than Ms. Kapusta actually standing in a better position. This is a case-by-case analysis when you're considering 112.316. So if the commission were to grant her request or approve the opinion, it doesn't mean that anyone in her position could come in and automatically get it. They would have to come before the commission, and based on their particular circumstances, either be granted permission to work or not. But in this particular case, because we have an opinion so close or on point with her situation, I believe that it would be less difficult for the commission to consider what to do. And just remember that 112.316 was specifically constructed to provide a way for individuals like Ms. Kapusta to follow the pursuit of a better opportunity for herself and her family, an opportunity which, like I said, has already been essentially determined and would not interfere, I believe, with the full and faithful discharge of her duties. All the factors that were considered previously are present here, except, again, she never served as an RMD.
Mr. Chair, may I follow? So it's not appropriate at this time to mention it, but I shall anyhow, that I intend to support this, but I think the gist of the questions tend to indicate that it has a little more to do with the management of the contract post the securing and the road that we may be walking down. What precedent would we be setting there? I understand the statute that you're citing is intended to make it easier for those who have given their lives to public service to pursue private lives after that, but how do we avoid the peril down the road?
Well, in this case, I think it's very important to note that Ms. Kapusta specifically had a limited to non-existent role in relation to the contracts. Now, if she had more involvement, I don't believe we would be here. It wouldn't be a close call or something to really consider as much, but we're talking about a limited to non-existent role regarding the two contracts that DCF has with her prospective employer, and that's important to know.
Through the chair, and how is that limitation pointed out here? I understand in both situations it was time, and then through the testimony today, which I would accept and agree with, it was because of buffers or other attention areas. But I think since we're talking precedences here, we're thinking beyond the instant case here, if I'm not mistaken.
And correct me if I'm wrong, Executive Director and General Counsel, but when you talk about 112.316, even though a requester may look to previous opinions, it is a case-by-case analysis. And in this case, there are several factors that distinguish Ms. Kapusta from any other case. Number one, the relevant contracts were negotiated, entered into, and signed by other persons than Ms. Kapusta. Number two, when the contracts were signed, Ms. Kapusta did not manage or monitor any DCF employee. And three, unlike her former colleague, the requester in 1220, she never served as the director of any DCF region. Not saying it's impossible, but it's unlikely that anyone going forward would come in with these particular facts, just like her facts are different from the previous requester, putting her in a better light, so to speak.
Commissioner Lesnar.
I understand there may not have been any oversight of the contract, and I don't know whether this is a question that council needs to jump in on or not, but the CBC program is a very large one. It has a lot of policy and fiscal associations that apply to many contractors. Did you, in any capacity, oversee the CBC program in your roles?
So I'm not sure I understand your question, and I apologize.
Whether there was management, I understand and accept that there was no involvement in your management of this particular contract. However, CBCs in general benefit or don't benefit from a variety of policies or interpretation or general practices by the department and fiscal distributions, et cetera. So my question is, did you have oversight over the CBC program?
So the CBC financial award is statutorily set forth. It's a formula. So it's not something that the department has any ability to say, we're going to give X amount of dollars, or it's not negotiated in terms of dollars.
Except you do make requests, and you make requests for amendments, et cetera, to the legislature.
I never did. I never made any requests.
Yeah, I meant when I said you meant, I should have said the agency.
Yes, the agency does have the authority to do that. Ordinarily, it's what's done through a risk pool application. So there's a risk pool set aside. The legislature determines how much money gets put into that risk pool. And then it is, if there's not enough, because there's a shortfall, which ordinarily is the circumstances, these CBCs then go lobby for back of the bill money. But in terms of the CBCs are statutorily mandated in Chapter 409. You have to have one CBC per judicial circuit. They began in 2001. We began rolling out that privatization effort in 2001. We finalized privatization in 2006 in our southern region down in Miami. I had begun my employment with the department in 2002 as a line attorney in Bradenton, Florida. So I really wasn't involved in the policy or forming of the CBCs. If that answers your question.
Not quite, because there's always ongoing issues with CBCs. They're such a huge program. Do you have responsibilities, or did you have responsibilities regarding the overall management of that program, not the contractor, but the program of community-based care?
We don't really have a program, if you will. We have Office of Child Welfare, we have substance abuse, mental health. They all involve services that are rolled out to our families and the children that we are serving in those areas. That we don't have our contracts, and our contract unit oversees performance of those, and they run up through the Assistant Secretary of Administration. So it's not even my area that I was ever involved in. As interim secretary, it would have ultimately come up to me. However, it did not at the time that I was interim secretary.
Thank you.
Yes, General Counsel.
Thank you, Mr. Chairman. Through the chair, Commissioner Lesnoff, in relation to what you were asking about there about the overall program or the subject matter, and did you have any responsibility in regard to that? The way that the statute is written and has been interpreted several times by the commission is that it goes only to having a certain amount of responsibility in relation to a particular contract, and the commission has said that it's contract specific in its prohibition rather than subject matter or program general.
Thank you.
And if I might further through the chair, Commissioner Carvajal, what you were saying about the difference in the one statute and the other, and the role or lack thereof in the inception of the contract or the awarding of it versus the monitoring of it, the statute really at issue here is the latter. And the reason that the draft proposes to apply 112.316 is that whatever responsibility she had would have been vicarious through the subordinates, which sometimes can be enough to trigger the statute, but here in this particular instance, it was fairly anemic. So you are right in that the statute the inception of it is not the only thing. You could have a problem if you monitor it, but it just looks like here that it was just so anemic in terms of her personal monitoring in a vicarious sense that it would be appropriate to go with the way that the draft is.
May I add? I apologize. I don't know the protocols here, so I apologize if I'm
You're
breaking
doing
them.
fine. Go right ahead.
So, in the opinion 1220, that individual who was a former employee of the department who served in my same exact role, Assistant Secretary of Operations, also served for 5 years as Regional Managing Director. A new contract was procured in that single region with the same CBC that had existed for the same 5 years under that Assistant Secretary of Operations while he was serving as Regional Managing Director. The new contract was procured and entered into. He served for 10 months. And then 10 months later, he became Assistant Secretary of Operations. So he had much more significant involvement in that contract. I didn't even know Eckerd existed, and I'm not saying that to be slight. I really didn't know. I was in the Northwest region, so I had no involvement in their procurement or in their management or in their board of directors at the time that they were procured and awarded the contract.
Any further questions for the respondent? Going once. All right. We have no further questions for you, Ms. Kapusta. Thank you very much. All right, members, you've heard from counsel, you've heard from the respondent, you've had your questions. Do we have a motion?
So moved to accept the post-employment restrictions as listed in, as presented.
Okay, so we have a motion from Commissioner Carbajal, second, I believe that was from Commissioner McManus, down to my left. Motion's on the table. Is there any discussion? Commissioner Brady.
With malice toward none, I would assume that these post-employment restrictions are really designed to talk about general influence rather than specific influence. And as we have looked at most of these over the course of my last 3.5 years, they've tended to be relatively low-level people in kind of collateral positions who may or may not have exact responsibility for the activity which they are moving to. It is relatively clear to me, given the situation in Miami, that the Secretary of the Department of Family and Children has the ultimate authority to go through and approve the CBC contracts, which hypothetically they're going to make a decision on sometime this week. And it's also very clear to me that the General Counsel, Director of Operations, and Interim Secretary are extremely important and powerful positions inside the Department of Children and Families. So that any malice, I mean, I think the statutes are really designed to say that the more central and important your role is in the agency, the more scrutiny should be provided in terms of allowing you to go to a contractor to that agency in terms of having the ability to influence decisions. Clearly, this is compounded by the fact that we've got a new governor and we've got a new secretary of DCF, and my guess is anybody who is part of the old regime will have relatively little influence in the new, but it strikes me as naive to believe that the General Counsel, Director of Operations, and Interim Secretary does not play a role in the overall management of the Department of Children and Families, and the CBC program, to be candid, is one of its major part of its mission and one of its larger programs.
Thank you, Commissioner Brady. Any other discussion? Yes, Commissioner Carbajal.
I think, again, if you elevate the question to beyond this particular case, the point here, and is the one that I would have concerns with, is the appearance, to the public at least, that somebody who had authority might be using that authority otherwise. And what's given me comfort, at least in this case and what would be in futures, is the assurance that this doesn't set a precedence for everybody. They still have to appear here. So we become, to some degree, the lens for the public to analyze those things. As long as this opinion is not changing, that those people have to appear here, that there's not an automatic approval, even if the cases are almost mirrored, then I have comfort in supporting this, because we become the conscious of this case, and I don't know that we should. I think I'm just as concerned about ensuring that people who are in the public system continue to rise and provide the service without foreclosure their futures as well. But we would not want them to manipulate that future to some degree. So I intend to support this.
Any further discussion?
Well, as I understand it, the degree to which the particular department employee is substantially and personally involved is part of the question. Is that right?
Yes.
So I think the record here is that she was not substantially and personally involved. So I would support the opinion.
Thank you, Commissioner. Any other discussion? Seeing none, we'll call the question. All in favor of the staff council recommendation with respect to this advisory opinion, please say aye.
Aye.
Any opposed, nay?
Nay.
Is there a need for a roll call? Chair, in the opinion of Chair, the ayes have it. Motion carries. Ms. Kapusta, congratulations, and thank you for bringing this matter before the commission. It's very important that our public employees do so when they have things like that. It appears that staff and the commission have found that you properly threaded the needle. So congratulations and good luck to you. Commissioners, we'll move on to item 7, consideration of financial disclosure appeals. We have a number of matters with no hearing. Let's see. So please note that on item number 2 of the list, financial disclosure 2017-134, Zulema Felix has been removed from the agenda. There are no appeals in which the appellant has asked to be heard. Would any member like to hear from the staff as to these cases, or is there a motion?
I would make a motion to approve the recommendation for items 1, 3, 4, and 5 in Moss as so recommended.
Thank you, Mr. Commissioner Berger. We have a second from Commissioner Lesnov. Is there any discussion on the motion? Seeing none, motion is to approve 1, 3, 4, and 5 on Moss. All in favor, please say aye. Aye. Any opposed, nay. Thank you very much. Item 8 on our public agenda today is consideration of second order on request for extension. This is brought to us in Re Peggy Quince, case number 2019-01. This is one of our former Supreme Court justices, and I believe that the chair has granted a 45-day extension, but the justice requested a further extension due to being out of the country. Mr. Schaefer, you want to provide the commission with any background on that? I believe you're
I'd be happy to, Chair. As you said, this extension request has been brought by former Supreme Court Justice Peggy Quince. I believe she's out of the country traveling. She retired on January 7th of this year. That triggered a 60-day requirement for her to file her Form 6F that actually expires today, March 8th. She's indicated she won't be back in the country until mid-May, and so she's asked for an extension until July 1st to get all of her materials together to submit the Form 6F. The chair has statutory authority to grant a 45-day extension based on good cause, which he's done. It will extend from March 8th to April 22nd. The order before you for approval today is just to grant an additional extension from April 22nd to July 1st so that she can get her materials together and get the form filed. I present the draft order for your review.
We have a motion. Is there a second?
Second.
Seconded by Commissioner Berger. Any discussion? Seeing none, all in favor, please say aye. Aye. Opposed, nay. Motion carries. Thanks for backing up the chair. Item 9 is consideration of order declaring financial disclosure fine uncollectible, case number, or In Re Elvin McCorvey regarding the 2016 CE Form 1. So after a final order imposing the fines, recommended that we declare the fine uncollectible, in this case because of the death of the filer. Are there any questions from the members?
Yes. I was wondering, when we have that kind of a situation, is there any review to see if there is a probate estate of some value, or you would just not want to go there?
Please.
Commissioner, the commission has essentially never wanted to go there. We've never sought to assess the value of the estate of deceased financial disclosure filers. In other contexts, we have, but not in financial disclosure.
Okay, thank you.
Commissioner McManus, we do such a great job beating up on the living, we decided to let the dead have a break. So,
That's what I was thinking.
exactly, right. So, leaving these things to a higher authority in that case. So, all right. Do we have a motion on item 9?
So moved.
We have a motion from Commissioner Carbajal. Is there a second?
Second.
Second from Commissioner Lesnov. Any discussion besides the inappropriate comments of the chair? Seeing none, all in favor, please say aye.
Aye.
All opposed, nay. Motion carries. All right. Yeah, I know this will disappoint everybody, but we're moving on to the reports. First report from the chair. I will just briefly say that we are continuing some efforts of discussion between the chair and members of the staff with regard to the annual dinner that we have, that this year we might, I don't know, say a couple of nice words about our outgoing executive director at that time. So there had been some discussion of doing that in June. All things being considered, it has been determined that we will stick with July, which is our normal time. The executive director, who will no longer be under any control of the commission at that time, has nevertheless sworn that she will attend that dinner, will not be traveling in Europe or seeking any extensions or anything along those lines at that time. And so we will have a good time. And I have also just mentioned to staff that despite the special occasion, it's my opinion with regard to the matter, this is always a staff-friendly event and intended to be a staff-friendly event and for the staff, and we want to keep that theme, if you will. This is about celebrating our staff, and so price point and all those different factors we want to keep consistent. Nonetheless, I hope that we will have the opportunity to invite former commissioners, particularly the ones that served under Ms. Dawes. We might even invite Mr. Herron and have them come and join us for that great occasion to say thank you and goodbye to our outstanding executive director. Other than that, I don't have anything to report.
Well, I don't have anything in the executive director's report, but lest you think you would get off that easily, I do have some things regarding legislation. Things, of course, always just start happening fast and furious the week before the session starts and the week of session. To add to the written report that I sent out to you, the House Bill 1, which essentially is similar to legislation that's been proposed in prior years, which expands restrictions and reporting requirements on all kinds of public officers and employees, now has a Senate companion, and but it hasn't been heard in any, I think it's been workshopped in the House. It hasn't been heard in the Senate. There are bills in the House and Senate that would repeal the blind trust legislation that was enacted in the major ethics bill of 2013. The Senate bill will be heard next week. That's really so interesting to me because the blind trust was the Ethics Commission's recommendation, and it was heralded as a really great idea by the press and everybody else at the time, but now as time passes, nobody likes it anymore, so I'll be interested to see what's happened with that, or what will happen with that. Of major significance to us are the House and Senate bills, which would require financial disclosure to be moved to an electronic format versus the paper ones that everyone fills out now. Under both the House and Senate bills, Form 6 filers would start filing electronically, or be able to file electronically as of January 1, 2022, and Form 1 filers as of January 1, 2023. So we would phase it in. The bills initially had a shorter time frame. The House and Senate were both very interested in our input, and they moved it back to the longer time frame. Really, the only thing I'm concerned about at this point is the appropriation that goes along with these bills, because we need to have enough, and I have to say, I don't know what the dollar amount is because I'm not the tech person. I don't know what it costs to build this system. But I do know that we cannot have an e-filing system just glued on top of the current financial disclosure management system we have now, because that system is on its last legs. It's 15, 16 years old, and it would be like, putting a beautiful, shiny new second story on top of a shack. So I'm hoping that whatever the final number comes out to be, it will include updating that current system, and I have made the point over and over again that if that is not done, then there's a very big chance of failure of the system when somebody pushes that button to submit their disclosure, and I don't want it to be said it's the commission's fault, because we told them we needed the money for it. There's a couple other bills that I have a little bit of concern about, but I hope they're going to get changed a little bit as they go through. There's a bill regarding information related to victims of sexual harassment or sexual misconduct, which would potentially relate to some of our cases. Well, there's a bill that would put us in charge of sexual harassment. But in addition to that, this one deals with information related to the victims of sexual harassment or misconduct. And in addition to any information that could identify the victim, it also requires us to keep confidential any information that could assist an individual in determining the identity of the alleged victim. That, to me, is really going to be hard to implement, because what could assist somebody in determining the identity of someone else depends on what you already know. I mean, if you know that the act took place in Tallahassee and the commission reveals that this occurred in Tallahassee, then you could figure out who the victim is. But if you don't know where in the state it took place, just telling someone that it took place in Tallahassee wouldn't necessarily do it. So I'm really concerned about actually us getting sued over that when we try to implement it. But again, I'm hoping that that'll get straightened out as the bill moves along. The sponsor has been extremely courteous to us, and Carrie and I went and spoke to her, and she was very interested in our input. There's another bill which says for public meetings, you would have to provide the meeting materials and make them public at least 3 days in advance. Well, that's all very nice, except that sometimes we get things from complainants or respondents the day before a meeting. And so that would, I'm afraid, leave us in the position of having to move it till the next meeting, so I'm a little worried about that. But, Carrie and I have been working really hard with staff and with the members, and so we're hoping that all of these get straightened out. And then last but not least, we have one bill in the Senate with no House companion, but that adopts the Commission's voting conflicts and attorney's fees recommendations. And so it's always nice to see some of our recommendations make it into bill form, even if it's only on one side. I can't remember what movie it was, but I think the phrase is, "We got a shot." So that is my report on legislation.
As a connoisseur of all those kinds of movies, I'm pretty sure I know which one it was, but anyway. All right, any questions for our executive director? Thank you very much. I encourage our members to reach out to your legislator contacts. I think that this electronic filing thing coming down the pike is going to be a big deal, and it needs to be done seamlessly. I suggested to to my House representative that it was always that these House members, legislators, are always welcome to come see the commission in action, and at a time other than when they might be here for a complaint. And we'd love for them to give some thought ahead of time to the electronic filing mandate that will be coming down on the commission, and fund it appropriately. We're the third largest state. We need an ethics commission that mirrors what it ought to look like for the third largest state in our union. Any other comments for the go of the order? Seeing none, we will adjourn.
That brings to mind a question.
Yes, sir.
How many Form 6s, or how many officials in a year have to file a Form 6?
Through the chair, the Form 6s all come to us, and there are about 1,600 of them, counting judges. Where's Kim? She'll correct me. Oh, she's hiding over there. So we have that. And then with the Form 1s that come to us, there are about 16,000, and the rest go to the supervisors of elections. Under electronic filing, only because it just makes sense for them all to be filed in one place, they would all come to us. Oh, I left out, the other concern I have about this bill as it's currently drafted, or as I think the House envisions it anyway, is that all the forms filed by all the candidates in all races throughout the state would come to the commission. I don't really feel like a 25-person commission should have that role. I mean, it's just, honestly, it's just too much. They have elections at different times. There's 460-something municipalities. I think that aspect of it would be really difficult, but we'll see what happens as the bill moves forward.
Thank you.
We have a motion to adjourn. Motion's approved. We're adjourned. Thank you.